Paris Convention for the Protection of Industrial Property. Article 1 Establishment of the Union Scope of Industrial Property. 1. The countries to which this convention applies constitute a union for the protection of industrial property. 2. The protection of industrial property has as its object patents, utility models, industrial designs, trademarks, service marks, trade names, indications of source or appellations of origin, and the repression of unfair competition. 3. Industrial property shall be understood in the broadest sense and shall apply not only to industry and commerce proper, but likewise to agricultural and extractive industries and to all manufactured or natural products, for example, wines, grain, tobacco leaf, fruit, cattle, minerals, mineral waters, beer, flowers, and flour. 4. Patents shall include the various kinds of industrial patents recognized by the laws of the countries of the Union, such as patents of importation, patents of improvement, patents and certificates of addition, etc. Article 2 National treatment for nationals of countries of the Union. 1. Nationals of any country of the Union shall, as regards the protection of industrial property, enjoy in all the other countries of the Union the advantages that their respective laws now grant, or may hereafter grant, to nationals all without prejudice to the rights specially provided for by this convention. Consequently, they shall have the same protection as the latter, and the same legal remedy against any infringement of their rights, provided that the conditions and formalities imposed upon nationals are complied with. 2. However, no requirement as to domicile or establishment in the country where protection is claimed may be imposed upon nationals of countries of the Union for the enjoyment of any industrial property rights. 3. The provisions of the laws of each of the countries of the Union relating to judicial and administrative procedure and to jurisdiction, and to the designation of an address for service or the appointment of an agent, which may be required by the laws on industrial property are expressly reserved. Article 3 Same treatment for certain categories of persons as for nationals of countries of the Union. Nationals of countries outside the Union who are domiciled or who have real and effective industrial or commercial establishments in the territory of one of the countries of the Union shall be treated in the same manner as nationals of the countries of the Union. Article 4a. 1. Any person who has duly filed an application for a patent, or for the registration of a utility model, or of an industrial design, or of a trademark, in one of the countries of the Union, or his successor in title, shall enjoy, for the purpose of filing in the other countries, a right of priority during the periods hereinafter fixed. 2. Any filing that is equivalent to a regular national filing under the domestic legislation of any country of the Union or under bilateral or multilateral treaties concluded between countries of the Union shall be recognized as giving rise to the right of priority. 3. By regular national filing is meant any filing that is adequate to establish the date on which the application was filed in the country concerned, whatever may be the subsequent fate of the application. Article 4b. Consequently, any subsequent filing in any of the other countries of the Union before the expiration of the periods referred to above shall not be invalidated by reason of any acts accomplished in the interval, in particular, another filing, the publication or exploitation of the invention, the putting on sale of copies of the design, or the use of the mark, and such acts cannot give rise to any third-party right or any right of personal possession. Rights acquired by third parties before the date of the first application that serves as the basis for the right of priority are reserved in accordance with the domestic legislation of each country of the Union. Article 4c. 1. The periods of priority referred to above shall be 12 months for patents and utility models, and 6 months for industrial designs and trademarks. 2. These periods shall start from the date of filing of the first application. The day of filing shall not be included in the period. 3. If the last day of the period is an official holiday, or a day when the office is not open for the filing of applications in the country where protection is claimed, the period shall be extended until the first following working day. 4. A subsequent application concerning the same subject as a previous first application within the meaning of paragraph 2, above, filed in the same country of the Union shall be considered as the first application, of which the filing date shall be the starting point of the period of priority, if, at the time of filing the subsequent application, the said previous application has been withdrawn, abandoned, or refused, without having been laid open to public inspection and without leaving any rights outstanding, and if it has not yet served as a basis for claiming a right of priority. The previous application may not thereafter serve as a basis for claiming a right of priority. Article 4D. 1. Any person desiring to take advantage of the priority of a previous filing shall be required to make a declaration indicating the date of such filing and the country in which it was made. Each country shall determine the latest date on which such declaration must be made. 2. These particulars shall be mentioned in the publications issued by the competent authority, and in particular in the patents and the specifications relating thereto. 3. The countries of the Union may require any person making a declaration of priority to produce a copy of the application, description, drawings, etc., previously filed. The copy, certified as correct by the authority which received such application, shall not require any authentication, and may in any case be filed, without fee, at any time within 3 months of the filing of the subsequent application. They may require it to be accompanied by a certificate from the same authority showing the date of filing, and by a translation. 4. No other formalities may be required for the declaration of priority at the time of filing the application. Each country of the Union shall determine the consequences of failure to comply with the formalities prescribed by this article, but such consequences shall in no case go beyond the loss of the right of priority. 5. Subsequently, further proof may be required. Any person who avails himself of the priority of a previous application shall be required to specify the number of that application. This number shall be published as provided for by paragraph 2, above. Article 4E. 1. Where an industrial design is filed in a country by virtue of a right of priority based on the filing of a utility model, the period of priority shall be the same as that fixed for industrial designs. 2. Furthermore, it is permissible to file a utility model in a country by virtue of a right of priority based on the filing of a patent application, and vice versa. Article 4F. No country of the Union may refuse a priority or patent application on the ground that the applicant claims multiple priorities, even if they originate in different countries, or on the ground that an application claiming one or more priorities contains one or more elements that were not included in the application or applications whose priority is claimed, provided that, in both cases, there is unity of invention within the meaning of the law of the country. With respect to the elements not included in the application or applications whose priority is claimed, the filing of the subsequent application shall give rise to a right of priority under ordinary conditions. Article 4G. 1. If the examination reveals that an application for a patent contains more than one invention, the applicant may divide the application into a certain number of divisional applications and preserve as the date of each the date of the initial application in the benefit of the right of priority, if any. 2. The applicant may also, on his own initiative, divide a patent application and preserve as the date of each divisional application the date of the initial application in the benefit of the right of priority, if any. Each country of the Union shall have the right to determine the conditions under which such division shall be authorized. Article 4H. Priority may not be refused on the ground that certain elements of the invention for which priority is claimed do not appear among the claims formulated in the application in the country of origin, provided that the application documents as a whole specifically disclose such elements. Article 4I. 1. Applications for inventors' certificates filed in a country in which applicants have the right to apply at their own option either for a patent or for an inventor's certificate shall give rise to the right of priority provided for by this article, under the same conditions and with the same effects as applications for patents. 2. In a country in which applicants have the right to apply at their own option either for a patent or for an inventor's certificate, an applicant for an inventor's certificate shall, in accordance with the provisions of this article relating to patent applications, enjoy a right of priority based on an application for a patent, a utility model, or an inventor's certificate. Article 4 bis. Patents, independence of patents obtained for the same invention in different countries. 1. Patents applied for in the various countries of the Union by nationals of countries of the Union shall be independent of patents obtained for the same invention in other countries, whether members of the Union or not. 2. The foregoing provision is to be understood in an unrestricted sense, in particular, in the sense that patents applied for during the period of priority are independent, both as regards the grounds for nullity and forfeiture, and as regards their normal duration. 3. The provision shall apply to all patents existing at the time when it comes into effect. 4. Similarly, it shall apply, in the case of the accession of new countries, to patents in existence on either side at the time of accession. 5. Patents obtained with the benefit of priority shall, in the various countries of the Union, have a duration equal to that which they would have, had they been applied for or granted without the benefit of priority. Article 4 Terre patents, mention of the inventor in the patent. The inventor shall have the right to be mentioned as such in the patent. Article 4 Quater patents, patentability in case of restrictions of sale by law. The grant of a patent shall not be refused and a patent shall not be invalidated on the ground that the sale of the patented product or of a product obtained by means of a patented process is subject to restrictions or limitations resulting from the domestic law. Article 5a. 1. Importation by the patentee into the country where the patent has been granted of articles manufactured in any of the countries of the Union shall not entail forfeiture of the patent. 2. Each country of the Union shall have the right to take legislative measures providing for the grant of compulsory licenses to prevent the abuses which might result from the exercise of the exclusive rights conferred by the patent, for example, failure to work. 3. Forfeiture of the patent shall not be provided for except in cases where the grant of compulsory licenses would not have been sufficient to prevent the said abuses. No proceedings for the forfeiture or revocation of a patent may be instituted before the expiration of 2 years from the grant of the first compulsory license. 4. A compulsory license may not be applied for on the ground of failure to work or insufficient working before the expiration of a period of 4 years from the date of filing of the patent application or 3 years from the date of the grant of the patent, whichever period expires last it shall be refused if the patentee justifies his inaction by legitimate reasons. Such a compulsory license shall be non-exclusive and shall not be transferable, even in the form of the grant of a sublicense, except with that part of the enterprise or goodwill which exploits such license. 5. The foregoing provisions shall be applicable, mutatis mutandis, to utility models. Article 5b. The protection of industrial designs shall not, under any circumstance, be subject to any forfeiture, either by reason of failure to work or by reason of the importation of articles corresponding to those which are protected. Article 5c. 1. If, in any country, use of the registered mark is compulsory, the registration may be cancelled only after a reasonable period, and then only if the person concerned does not justify his inaction. 2. Use of a trademark by the proprietor in a form differing in elements which do not alter the distinctive character of the mark in the form in which it was registered in one of the countries of the Union shall not entail invalidation of the registration and shall not diminish the protection granted to the mark. 3. Concurrent use of the same mark on identical or similar goods by industrial or commercial establishments considered as co-proprietors of the mark according to the provisions of the domestic law of the country where protection is claimed shall not prevent registration or diminish in any way the protection granted to the said mark in any country of the Union, provided that such use does not result in misleading the public and is not contrary to the public interest. Article 5d. No indication or mention of the patent, of the utility model, of the registration of the trademark, or of the deposit of the industrial design, shall be required upon the goods as a condition of recognition of the right to protection. Article 5 bis. All industrial property rights, period of grace for the payment of fees for the maintenance of rights patents, restoration. 1. A period of grace of not less than 6 months shall be allowed for the payment of the fees prescribed for the maintenance of industrial property rights, subject, if the domestic legislation so provides, to the payment of a surcharge. 2. The countries of the Union shall have the right to provide for the restoration of patents which have lapsed by reason of non-payment of fees. Article 5 Terre patents, patented devices forming part of vessels, aircraft, or land vehicles. In any country of the Union the following shall not be considered as infringements of the rights of a patentee. 1. The use on board vessels of other countries of the Union of devices forming the subject of his patent in the body of the vessel, in the machinery, tackle, gear and other accessories, when such vessels temporarily or accidentally enter the waters of the said country, provided that such devices are used there exclusively for the needs of the vessel. 2. The use of devices forming the subject of the patent in the construction or operation of aircraft or land vehicles of other countries of the Union, or of accessories of such aircraft or land vehicles, when those aircraft or land vehicles temporarily or accidentally enter the said country. Article 5 Quater Patents, importation of products manufactured by a process patented in the importing country. When a product is imported into a country of the Union where there exists a patent protecting a process of manufacture of the said product, the patentee shall have all the rights, with regard to the imported product, that are accorded to him by the legislation of the country of importation, on the basis of the process patent, with respect to products manufactured in that country. Article 5 Quinquies Industrial Designs. Industrial designs shall be protected in all the countries of the Union. Article 6 Marks, Conditions of Registration Independence of protection of same mark in different countries. 1. The conditions for the filing and registration of trademarks shall be determined in each country of the Union by its domestic legislation. 2. However, an application for the registration of a mark filed by a national of a country of the Union in any country of the Union may not be refused, nor may a registration be invalidated, on the ground that filing, registration, or renewal, has not been effected in the country of origin. 3. A mark duly registered in a country of the Union shall be regarded as independent of marks registered in the other countries of the Union, including the country of origin. Article 6 Bis Marks, well-known marks. 1. The countries of the Union undertake, ex officio if their legislation so permits, or at the request of an interested party, to refuse or to cancel the registration, and to prohibit the use, of a trademark which constitutes a reproduction, an imitation, or a translation, liable to create confusion, of the mark considered by the competent authority of the country of registration or use to be well known in that country as being already the mark of a person entitled to the benefits of this convention and used for identical or similar goods. These provisions shall also apply when the essential part of the mark constitutes a reproduction of any such well-known mark or an imitation liable to create confusion therewith. 2. A period of at least 5 years from the date of registration shall be allowed for requesting the cancellation of such a mark. The countries of the Union may provide for a period within which the prohibition of use must be requested. 3. No time limit shall be fixed for requesting the cancellation or the prohibition of the use of marks registered or used in bad faith. Article 6 Tare Marks, Prohibitions concerning state emblems, official hallmarks, and emblems of intergovernmental organizations. 1a. The countries of the Union agree to refuse or to invalidate the registration, and to prohibit by appropriate measures the use, without authorization by the competent authorities, either as trademarks or as elements of trademarks, of armorial bearings, flags, and other state emblems, of the countries of the Union, official signs and hallmarks indicating control and warranty adopted by them, and any imitation from a heraldic point of view. b. The provisions of subparagraph a, above, shall apply equally to armorial bearings, flags, other emblems, abbreviations, and names, of international intergovernmental organizations of which one or more countries of the Union are members, with the exception of armorial bearings, flags, other emblems, abbreviations, and names, that are already the subject of international agreements in force, intended to ensure their protection. c. No country of the Union shall be required to apply the provisions of subparagraph b, above, to the prejudice of the owners of rights acquired in good faith before the entry into force, in that country, of this convention. The countries of the Union shall not be required to apply the said provisions when the use or registration referred to in subparagraph a, above, is not of such a nature as to suggest to the public that a connection exists between the organization concerned and the armorial bearings, flags, emblems, abbreviations, and names, or if such use or registration is probably not of such a nature as to mislead the public as to the existence of a connection between the user and the organization. 2. Prohibition of the use of official signs and hallmarks indicating control and warranty shall apply solely in cases where the marks in which they are incorporated are intended to be used on goods of the same or a similar kind. 3a. For the application of these provisions, the countries of the Union agree to communicate reciprocally, through the intermediary of the International Bureau, the list of state emblems, and official signs and hallmarks indicating control and warranty, which they desire, or may hereafter desire, to place wholly or within certain limits under the protection of this article, and all subsequent modifications of such list. Each country of the Union shall in due course make available to the public the lists so communicated. Nevertheless, such communication is not obligatory in respect of flags of states. B. The provisions of subparagraph B of paragraph 1 of this article shall apply only to such armorial bearings, flags, other emblems, abbreviations, and names, of international intergovernmental organizations as the latter have communicated to the countries of the Union through the intermediary of the International Bureau. 4. Any country of the Union may, within a period of 12 months from the receipt of the notification, transmit its objections, if any, through the intermediary of the International Bureau, to the country or international intergovernmental organization concerned. 5. In the case of state flags, the measures prescribed by paragraph 1 above shall apply solely to marks registered after November 6, 1925. 6. In the case of state emblems other than flags, and of official signs and hallmarks of the countries of the Union, and in the case of armorial bearings, flags, other emblems, abbreviations, and names, of international intergovernmental organizations, these provisions shall apply only to marks registered more than 2 months after receipt of the communication provided for in paragraph 3 above. 7. In cases of bad faith, the country shall have the right to cancel even those marks incorporating state emblems, signs, and hallmarks, which were registered before November 6, 1925. 8. Nationals of any country who are authorized to make use of the state emblems, signs, and hallmarks of their country may use them even if they are similar to those of another country. 9. The countries of the Union undertake to prohibit the unauthorized use and trade of the state armorial bearings of the other countries of the Union, when the use is of such a nature as to be misleading as to the origin of the goods. 10. The above provisions shall not prevent the countries from exercising the right given in paragraph 3 of Article 6 quinquis, Section B, to refuse or to invalidate the registration of marks incorporating, without authorization, armorial bearings, flags, other state emblems, or official signs and hallmarks adopted by a country of the Union, as well as the distinctive signs of international intergovernmental organizations referred to in paragraph 1 above. Article 6 Squatter marks, assignment of marks. 1. When, in accordance with the law of a country of the Union, the assignment of a mark is valid only if it takes place at the same time as the transfer of the business or goodwill to which the mark belongs, it shall suffice for the recognition of such validity that the portion of the business or goodwill located in that country be transferred to the assignee, together with the exclusive right to manufacture in the said country, or to sell therein, the goods bearing the mark assigned. 2. The foregoing provision does not impose upon the countries of the Union any obligation to regard as valid the assignment of any mark the use of which by the assignee would, in fact, be of such a nature as to mislead the public, particularly as regards the origin, nature, or essential qualities, of the goods to which the mark is applied. Article 6 quinquis Marks, protection of marks registered in one country of the Union in the other countries of the Union. Article 6 quinquis A. 1. Every trademark duly registered in the country of origin shall be accepted for filing and protected as is in the other countries of the Union, subject to the reservations indicated in this article. Such countries may, before proceeding to final registration, require the production of a certificate of registration in the country of origin, issued by the competent authority. No authentication shall be required for this certificate. 2. Shall be considered the country of origin the country of the Union where the applicant has a real and effective industrial or commercial establishment, or, if he has no such establishment within the Union, the country of the Union where he has his domicile, or, if he has no domicile within the Union but is a national of a country of the Union, the country of which he is a national. Article 6 quinquis B. Trademarks covered by this article may be neither denied registration nor invalidated except in the following cases. 1. when they are of such a nature as to infringe rights acquired by third parties in the country where protection is claimed. 2. When they are devoid of any distinctive character, or consist exclusively of signs or indications which may serve, in trade, to designate the kind, quality, quantity, intended purpose, value, place of origin, of the goods, or the time of production, or have become customary in the current language or in the bona fide and established practices of the trade of the country where protection is claimed. 3. When they are contrary to morality or public order and, in particular, of such a nature as to deceive the public. It is understood that a mark may not be considered contrary to public order for the sole reason that it does not conform to a provision of the legislation on marks, except if such provision itself relates to public order. This provision is subject, however, to the application of Article 10 bis. Article 6 quinquis c. 1. In determining whether a mark is eligible for protection, all the factual circumstances must be taken into consideration, particularly the length of time the mark has been in use. 2. No trademark shall be refused in the other countries of the Union for the sole reason that it differs from the mark protected in the country of origin only in respect of elements that do not alter its distinctive character and do not affect its identity in the form in which it has been registered in the said country of origin. Article 6 quinquis d. No person may benefit from the provisions of this article if the mark for which he claims protection is not registered in the country of origin. Article 6 quinquis z. However, in no case shall the renewal of the registration of the mark in the country of origin involve an obligation to renew the registration in the other countries of the Union in which the mark has been registered. Article 6 quinquis f. The benefit of priority shall remain unaffected for applications for the registration of marks filed within the period fixed by Article 4, even if registration in the country of origin is effected after the expiration of such period. Article 6 sexies marks, service marks. The countries of the Union undertake to protect service marks. They shall not be required to provide for the registration of such marks. Article 6 septies marks. Registration in the name of the agent or representative of the proprietor without the latter's authorization. 1. If the agent or representative of the person who is the proprietor of a mark in one of the countries of the Union applies, without such proprietor's authorization, for the registration of the mark in his own name, in one or more countries of the Union, the proprietor shall be entitled to oppose the registration applied for or demand its cancellation or, if the law of the country so allows, the assignment in his favor of the said registration, unless such agent or representative justifies his action. 2. The proprietor of the mark shall, subject to the provisions of paragraph 1, above, be entitled to oppose the use of his mark by his agent or representative if he has not authorized such use. 3. Domestic legislation may provide an equitable time limit within which the proprietor of a mark must exercise the rights provided for in this article. Article 7 Marks, nature of the goods to which the mark is applied. The nature of the goods to which a trademark is to be applied shall in no case form an obstacle to the registration of the mark. Article 7 bis marks, collective marks. 1. The countries of the Union undertake to accept for filing and to protect collective marks belonging to associations the existence of which is not contrary to the law of the country of origin, even if such associations do not possess an industrial or commercial establishment. 2. Each country shall be the judge of the particular conditions under which a collective mark shall be protected and may refuse protection if the mark is contrary to the public interest. 3. Nevertheless, the protection of these marks shall not be refused to any association the existence of which is not contrary to the law of the country of origin, on the ground that such association is not established in the country where protection is sought or is not constituted according to the law of the latter country. Article 8 Trade names. A trade name shall be protected in all the countries of the Union without the obligation of filing or registration, whether or not it forms part of a trademark. Article 9 Marks, trade names, seizure, on importation, etc., of goods unlawfully bearing a mark or trade name. 1. All goods unlawfully bearing a trademark or trade name shall be seized on importation into those countries of the Union where such mark or trade name is entitled to legal protection. 2. Seizure shall likewise be effected in the country where the unlawful affixation occurred or in the country into which the goods were imported. 3. Seizure shall take place at the request of the public prosecutor, or any other competent authority, or any interested party, whether a natural person or a legal entity, in conformity with the domestic legislation of each country. 4. The authorities shall not be bound to effect seizure of goods in transit. 5. If the legislation of a country does not permit seizure on importation, seizure shall be replaced by prohibition of importation or by seizure inside the country. 6. If the legislation of a country permits neither seizure on importation nor prohibition of importation nor seizure inside the country, then, until such time as the legislation is modified accordingly, these measures shall be replaced by the actions and remedies available in such cases to nationals under the law of such country. Article 10. False indications, seizure, on importation, etc., of goods bearing false indications as to their source or the identity of the producer. 1. The provisions of the preceding article shall apply in cases of direct or indirect use of a false indication of the source of the goods or the identity of the producer, manufacturer, or merchant. 2. Any producer, manufacturer, or merchant, whether a natural person or a legal entity, engaged in the production or manufacture of or trade in such goods and established either in the locality falsely indicated as the source, or in the region where such locality is situated, or in the country falsely indicated, or in the country where the false indication of source is used, shall in any case be deemed an interested party. Article 10 bis. Unfair competition. 1. The countries of the Union are bound to assure to nationals of such countries effective protection against unfair competition. 2. Any act of competition contrary to honest practices in industrial or commercial matters constitutes an act of unfair competition. 3. The following in particular shall be prohibited. 1. All acts of such a nature as to create confusion by any means whatever with the establishment, the goods, or the industrial or commercial activities, of a competitor. 2. False allegations in the course of trade of such a nature as to discredit the establishment, the goods, or the industrial or commercial activities, of a competitor. 3. Indications or allegations the use of which in the course of trade is liable to mislead the public as to the nature, the manufacturing process, the characteristics, the suitability for their purpose, or the quantity, of the goods. Article 10. Trademarks, trade names, false indications, unfair competition remedies, right to sue. 1. The countries of the Union undertake to assure to nationals of the other countries of the Union appropriate legal remedies effectively to repress all the acts referred to in Articles 9, 10, and 10 bis. 2. They undertake, further, to provide measures to permit federations and associations representing interested industrialists, producers, or merchants, provided that the existence of such federations and associations is not contrary to the laws of their countries, to take action in the courts or before the administrative authorities, with a view to the repression of the acts referred to in Articles 9, 10, and 10 bis, insofar as the law of the country in which protection is claimed allows such action by federations and associations of that country. Article 11. Inventions, utility models, industrial designs, marks, temporary protection at certain international exhibitions. 1. The countries of the Union shall, in conformity with their domestic legislation, grant temporary protection to patentable inventions, utility models, industrial designs, and trademarks, in respect of goods exhibited at official or officially recognized international exhibitions held in the territory of any of them. 2. Such temporary protection shall not extend the periods provided by Article 4. If, later, the right of priority is invoked, the authorities of any country may provide that the period shall start from the date of introduction of the goods into the exhibition. 3. Each country may require, as proof of the identity of the article exhibited and of the date of its introduction, such documentary evidence as it considers necessary. Article 12. Special National Industrial Property Services. 1. Each country of the Union undertakes to establish a special industrial property service and a central office for the communication to the public of patents, utility models, industrial designs, and trademarks. 2. This service shall publish an official periodical journal. It shall publish regularly. A. The names of the proprietors of patents granted, with a brief designation of the inventions patented. B. The reproductions of registered trademarks.